Good morning, good Saturday, good noon. Hello, everybody. I am your Lone Wolf Usul, and this is the Weekend Review. And today, y'all, I put together about 2 hours, almost 2.5 hours, of some pure courtroom drama for all of us to partake in. We're going to start things off with Middleton this morning. We have a few things happening in Middleton's court. Mostly they are jail related, but we do have the bond violation hearing that we saw brought before Middleton as an emergency motion. We actually get to see that hearing take place. After Middleton, then we're moving on to Judge Anzalone. And Judge Anzalone has several sentencings to get through before we finish off with Judge Rickey. And Judge Rickey is adjudicating in ways that Tommy Lee Jones can only adjudicate. So, ladies and gentlemen, get ready, get your coffee, get your snacks. It's gonna be a long one this morning. I've had a couple of days off. We had quite a bit of stuff to put together. Let's get started, shall we?
All right, Mr. Watkins, this is file number 241000SM. In this case, you're charged with domestic violence. You entered a plea to that charge, one count. We did a deferral. I set the matter for sentencing.
I just couldn't handle doing the probation.
Say that again.
I couldn't handle doing the probation.
Yes, it didn't go very well.
It's not that I couldn't pass the drug test or anything. It's that I couldn't get to the appointment.
Yes. Now, you've also got a hold on you from Indiana.
Yeah, and I don't understand how, because I swear to God, Gina said I was off paper.
I don't know the answer to that, Mr. Watkins. All I know is about this case. But also here with me is the two people from the public defender's office, including the chief public defender, Mr. Keith Stickley.
Okay.
I did the sentence, 30 days, credit 20, leaving 10 days deferred.
Yeah.
And I put you on a probation. And basically, you did a pretty good job on everything.
Yeah.
What Daniel Frazine said is the officers has nothing but polite and respectful interactions with the defendant during his last probation for operating while intoxicated on this one. This is not a deferral case. The charge is going to show up anyway. I'm recommending he simply do his 10 days jail and we close out the probation. Defendant called, said he just wants to do the jail days. He's been on probation so long that he wants to just get it over with. So I don't believe Daniel's here today, but how did you come to get arrested yesterday?
I was going to go to the psych ward and they ran my name.
Where are you staying?
I'm staying with my mom. I just got into an argument with my brother.
Down at the trailer park in White Pigeon?
Yeah.
Well, as you know, these are all family interactions. You guys can't live with each other or without each other. So you got arrested on Christmas Day.
Yeah, but it wasn't like I was fighting with them or anything. I got arrested on my own stupidity because they ran my name.
All right.
Like I wasn't arguing with them or nothing like that.
Okay.
I was trying to get my mental health right better.
Yes, I've been working on that. We have also. Maybe I can get you some help from Pivotal while you're in custody. Are you willing to waive your right to have a probation violation hearing on this matter and simply acknowledge that you weren't able to complete the terms of your probation.
Yeah, what does that interpret, like jail time wise?
10 days credit 1, leaving 9 days to serve. I'm going to
Yeah.
revoke your probation and allow you to go to Indiana to deal with your charges there.
Okay.
All right. Other than that, did anybody promise you anything to get you to plead to this
No, man,
or threaten you?
no. I'm confused about this whole Indiana thing. I thought I was off parole.
Well, I don't know what it's about. It has to do with a residential break-in. is
Yeah,
what the bailiff.
that was what I was on parole for.
All right, well, we'll sort it out.
I'm so confused over it. It's got me fucking, excuse my language, but irritated.
All right, well, we'll sort it out. Admits violation, waives right to hearing. Probation revoked. Waive all remaining fine and cost. 30 days jail. Credit 21.
So we're going to pay someone else to.
Laura, I need some more general judgments. Mr. Watkins, I'm gonna contact CMH, although if you're gonna be going to Indiana, I may not be very
Right.
successful. Anyway,
Right.
your probation is revoked. Waive all remaining fines and costs. 30 days, credit 21. 9 to serve. I'll indicate may be released to Indiana.
Okay.
What county is it?
LaGrange. I'm so confused on it too, man.
Well, they'll sort it out. If you're done, they'll figure that out. If you're not, you gotta go down there and take care of some unfinished business.
Right. The only thing I can think of is for like, maybe not completing community service or something, but I did everything else, all the classes,
Well,
everything.
all right, well, it may be that circumstance. Gina is retiring effective this Friday.
Right.
All right, Mr. Watkins, best of luck. This matter's done. You're off probation. You're gonna do some jail and we'll hope for the best.
Thank
Okay.
you.
All
Have a
right,
good
now
day.
all right, thank you.
In your queue.
Thank you very much. He's not even on the jail roster. He must have just got arrested. Let's log into that again. Have a seat, sir.
Thank you.
Good morning. I'm Judge Middleton. I'll be with you in just a minute. I'm handling the jail arraignments today because some of the staff is off. So I'm trying to get up to speed here. So give me just a minute. I thought I'd take care of this morning rather than make you wait till this afternoon.
I appreciate that. Thank you. Really appreciate that.
This is a bit of an odd circumstance.
Real. Maybe sell my house.
You did sell your house?
I have the tree farm guy just like 2 doors down willing to buy it. I just need to get out from these neighbors that don't like me anymore.
Well, he has a personal protection order against you, and that's what this is about.
Yes, sir.
Well, just
I,
hold up. Don't say anything yet.
I'm sorry. My bad. I'm sorry.
You're fine. Well, you're still not even on the list. Let me look, see if you're down here at the bottom.
Your Honor, when you get a minute, could I take a peek at the affidavit too, please?
Sure.
Thank you.
All right. Mr. Dealman, you're charged with stalking, which is a misdemeanor punishable by up to a year in jail. Let's pull this up and see what the actual complaint says.
Can I speak yet?
Yeah, well, in a minute. I'm here because somebody needs to be here. When somebody gets arrested on Christmas Day, they need a judge. So I'm it.
Yeah.
The allegation is that way back in March that you engaged in a course of conduct involving the harassment of Alan Thrasher. The conduct being such that it would cause a reasonable person to feel intimidated, and such conduct would cause him to feel threatened, harassed, or otherwise intimidated. So that was a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. This happened in March. Mr. Marvin authorized a criminal warrant in May, and they didn't get around to arresting you till Christmas Day. So how did you get arrested yesterday, Mr. Dealman?
Okay, sir. And actually it was Christmas Eve, sir. 3 o'clock, Christmas Eve. But basically what's going on is since 2020, these neighbors have been taunting and teasing me. Mr. Thrasher has threatened my life. I have been to the St. Joseph.
Well, wait, don't say more about that yet, but he has this PPO and you guys are next to each other and it's not a good situation. But how did they come to arrest you at 3 a.m. on Christmas Eve?
You know, I kind of would like to understand that too. They claimed that I was out in my yard. I was at my house in my yard and he drove by my house 3 or 4 times and kind of slowing down. And it just kind of, I just got home from shopping and it just kind of pissed me off, and excuse my words, but I just started yelling because he's the one that stalks me, but I'm getting in trouble.
No.
All right, okay, so who was driving by, Mr. Thrasher or the cops?
Mr. Thrasher, I have it on my home security system footage.
Sir, you need to stop making
All right,
statements
all right.
about that.
This is Mr. Wescombe. He's here from the public defender's office and he wants to make sure that that you don't compromise any of your rights.
Yes, sir. Thank you. Thank you. I need that.
Yes, you do.
I've been trying to get an attorney.
All right, I'll get you one here in just a minute.
Thank you, sir.
I don't have the PPO in front of me. I think it was authorized by Judge Tomlinson. I know Mr. Thrasher. I've known him since he was a kid and I was a kid back in the early 80s. On one matter or another when I was in the prosecutor's office. He got this PPO against you and apparently he alleges that you were yelling at him last night. But this warrant is from way back in last March. Well, nobody ever bothered to serve it. Officer Penn got a warrant for your arrest. Prosecutor Marvin authorized it in May, and then no one ever bothered to go serve the warrant on you, which is a common problem, which frustrates me. You still live at the Lakeview Road address?
Yes, sir. Hopefully short, not for long.
All right. So you plan to sell the property?
Yes, sir. The owner of the tree farm actually is guaranteeing by the first of the year.
Where will you move to?
Your Honor, I just gotta get out of St. Joseph because I have never been treated like this my whole life. I've done nothing wrong.
All right, well, I don't know. I am still trying to get my head around the fact of why you were outside at 3 a.m. on Christmas Eve yelling at your
PM.
neighbor.
PM, sir.
Oh, 3 in the afternoon?
Yeah, I just got home from shopping. Yes, sir. 3
I see.
PM.
I thought it was 3 a.m. All right, well, anyway, then you yelled at him and then apparently he called the cops. So then the police came to your house and arrested you?
Pretty much. I seen him drive by 3 or 4 times. I freaking yelled. I went in my house to tend to my babies, and next thing you know, the police were knocking on my door.
All right, so the police arrested you yesterday afternoon.
Christmas Eve, yes, sir.
All right,
Christmas Eve, not Christmas, but Christmas Eve.
I got you.
Okay, thank you.
I don't know if there's gonna be a new charge from that. I'm gonna show you plead not guilty. Had you been drinking or anything?
You know, I just poured a cocktail and I didn't even have a chance to finish it, sir. It's just the fact that he drove my house 4 times real slow and the way he was acting that frustrated me.
All right, we'll let your lawyer deal with that. Maybe I'll show you
sorry,
plead
I'm
not
just having a
guilty.
lawyer.
You're all right, I understand.
I'm sorry. Thank you, sir. Thank
Attorney,
you.
I'm not gonna let grass grow into this. I'm gonna set attorney pretrial for
Thank you, sir.
January 3rd, rather than kick it all the way out to February.
Thank you, sir.
2/5 at 8:30. So I'm gonna appoint a lawyer for him. I'm gonna set a pretrial for January 3rd. There is a personal protection order that prohibits you from having contact or engaging in harassing or threatening behavior. What happened here happened last March, and it appears some more may have happened yesterday. So I'm gonna set bond at $1,000 cash or surety. And same
Can I speak?
bond condition, no drugs and no alcohol, no contact with Alan Thrasher. No assaulty behavior, comply with PPO.
I don't need to leave my house, sir.
You said taking care of your babies. You got like pets in there or real babies?
Yeah, I got small, yeah, I do. I have 2 pets that's been alone for 2 days now. And I have
So you're-
nobody in my life, nobody.
So there's no one there to take care of your pets?
No, sir, it's driving me crazy.
Do you need a phone call or somebody to somebody?
I don't really have nobody to call, sir. I would really like to hope, since I've been in here 2 days, I can just get out.
Well, the problem
what I
is I
told
may
him.
let you out. They may immediately rearrest you on a new charge. So we'll sort this out.
Thank you.
What kind of animals are they?
There are 2 Rottweiler dogs. And
They're in the
all
house
animals, my wife died.
unattended?
yeah, they were worked up Christmas Eve because of what was going on. And then next thing you know, the police showed up and a police officer called me and told me that basically I wouldn't be arrested because I was trying to get
All right, all
a
right.
state police officer over there.
Now, here's some advice.
Yes,
Unless
sir.
you want about a $1 million bond, I don't want you to have any contact with Mr. Thrasher.
Yes, sir.
So standing
Yes,
out in
sir.
your yard yelling at him on Christmas Eve is a violation of your personal protection order. I didn't issue the order. I believe another judge did. And he ordered you to leave him alone. I can't help the fact that you guys are living next door to each other and you don't like each other. But it's your own damn fault. But the thought of these dogs being trapped in this house unattended until you get a hearing on January 3rd, it's not a pleasant prospect.
Thank you, sir. Thank you.
But I don't want you to have any contact with Mr. Thrasher.
Won't happen.
And one of the reasons is they never got around to arresting you. I guess if it wasn't that urgent from May to December, it isn't gonna be that urgent now. The reason I set a cash bond, a surety bond, is I think there may be a new stalking charge coming, but if it comes, it comes. We'll deal with it at that time.
Thank you, sir. Thank you.
$1,000 PR. Have you got a way to get home?
Thank you, sir. You know, I will call a cab. I will do whatever it takes. Now, I'm disabled, so I won't run, that's for sure.
Well, if you need a bus pass, stop here at the court and the bailiffs can give you one to get a bus pass.
Do they go to where I'm at living?
They'll take you where you need to go.
Thank you. I'm just unfamiliar, sir. I thank you,
Yeah,
sir. Thank you.
Do you have a coat? Did they arrest you wearing a coat?
I gotta go.
All right. I will see you on January 3rd.
Thank you.
Okay. This is file number 242131 FT, People versus Logan Keith Thomas. That's you, sir? You're here with your lawyer, Mr. Anastasi Marku. Also present is Prosecutor-elect Deborah Davis on behalf of the people. Mr. Logan, let's start at the beginning. You got charged in a complaint that was authorized by Ms. Davis earlier this month. Count 1 is operating with a suspended, revoked, or denied driver's license causing a death. It's alleged that on December 2nd in a snowstorm that you were driving with a suspended license, and by the operation of that vehicle did cause the death of a young man named Anthony Miller. Second count, you were operating the vehicle without any insurance. We get lots of people doing both of those things, driving suspended and driving without insurance. When there's a death, it becomes a felony, punishable by up to 15 years imprisonment and a fine of up to $10,000. You're also charged as a fourth habitual offender, making it theoretically punishable by up to life imprisonment. You were arraigned on that charge, and bond was set by me in the amount of, I believe it was $75,000 cash or surety.
I think it was 100,000.
100,000. Yes, there it is, 100,000 right in front of me. I ordered that you not use any drugs or alcohol. I ordered that you possess no weapons or firearms, no assaultive behavior, wear a GPS monitor, and no driving. I also ordered that you must report to the day reporting center on the very next day and sign the condition to agree for testing. So you did. I believe you're on the GPS monitor now, and you signed that on December 3rd. You and I were, I think, over the Zoom feed. I appointed Attorney Ross Truckee to represent you, and there were records made at that time that I set the bond about some previous fails to appear, possible case out of California, a driving suspended ticket in Kalamazoo from November. So bond was set in the substantial amount of $100,000. pre-exam conference was originally set. It's hard to do this in electronic form. For an earlier date, it's presently set for January 7th, which is my day. As I indicated, Mr. Truckee was counsel at that time. There was discussion that you were in discussion with the Levine and Levine law firm, the Marcoux law firm, and that you were going to be retaining Anastasi Marcoux, and he's here with you today. Sometime last week, I think this substitution was executed. It hadn't made it to the file at the time I dealt with this last week. There was a notice that we received on Monday, December 16th from the Day Reporting Center. It was Monday, December 16th was the date of the test. It was filed with the court on December 20. Well, it was filed with somebody, I guess us, on December 21st. December 21st was Saturday. So I don't know when we saw it. We first saw it on the 23rd. Ms. Davis saw it, and she moved to cancel your bond. She filed a written motion to cancel the bond, indicating that you should show cause why you should not be brought before the court for bond violation. The test
There's actually, the test was on the 16th.
16th.
The notice of the results was received on Thursday, the 19th.
All right, the one we had has a date of the 21st on it, which is a Saturday. You might have got it before we did.
That's, I think, when Pam from DRC emailed it to everybody was on Saturday. I had gotten it from them on Thursday prior to them filing that motion.
I think that's correct. The test printed result is from the 19th. However, the test is from the 16th. I don't know when either the prosecutor or the court received those results.
Right. Now, we had a very short notice emergency hearing on Friday afternoon or Monday, the 23rd, the last day before the Christmas holiday.
Typically, it was on the 19th.
No, it was the 23rd. Oh, no, you're right. It was, let me look at my note here. It was on the 20th.
Yeah, that Friday.
Friday, not the Friday. I wasn't here Monday. It was Friday. It just felt like the last day because it was my last day. So we had an emergency hearing, show cause why bond should not be revoked. Notice was not given. They attempted to, but Mr. Thomas wasn't here. Mr. Marcoux wasn't here. And Mr. Truckee wasn't here, and neither was the public defender. I learned that a substitution was forthcoming, and Ms. Davis cited the court rule that allows the court to do a bond violation. I was not clear and still wasn't clear what my authority was to immediately revoke bond without any sort of hearing or due process. So I set the matter for hearing this morning. Ms. Davis represented at that earlier hearing that the laboratory reports have come back regarding the defendant's drug and alcohol tests at the time of the accident, and that they intended to be amending the charges. The petition to revoke the bond All right. And the motion to cancel bond states, and on 12/19, the prosecutor received the MSP lab report. Now, that would be for the actual driving, indicating the defendant at the time of the accident was positive for methamphetamine, fentanyl, and morphine, as well as amphetamines. They also allege that you have 3 previous operating while intoxicated convictions. And that on the 19th, the results were received back from the day reporting center that you tested positive for methamphetamine and amphetamines on December 19th. Ms. Davis obviously was not very happy about that. Frankly, neither was I. And she asked me to revoke your bond. And is that still your request here, Ms. Davis?
Yes, Your Honor, just to kind of clarify, bring the court up to speed too. We haven't amended yet because we're waiting for the computer crimes unit from MSP to give us the report on the telephone usage, which could end up resulting in an additional charge of reckless driving causing death. So at least the amendment now that we know will be happening is OWI causing death, which is a 15-year as a habitual fourth, and OWI third, which would be a lesser included, depending on how that comes out, which is a 5-year, but also a habitual fourth. With the bond conditions that have been in place, it's my understanding from Attorney Marcoux that defendant has not been tested since the 16th. And so I guess part of our discussion prior to the hearing was, I'd like to have him test right now. And if it's a positive, then I would still be asking for his bond to be canceled. And if he passes it, I would leave it to the court's discretion as far as a punishment or some sort of repercussions for the use of illegal substances while on bond. Obviously not immune to the idea that, with the recovery and relapse do happen, but this is a very serious situation. And Your Honor was obviously less concerned about the use because he wasn't driving, but we can't guarantee that he's not driving. We do have the GPS tether on him, which has been effective. And so we can kind of keep an eye on where he's going, but we really would like to get a handle on the substance issue. I also, in the emails with Pam from DRC, trying to get a handle on how they're doing the testing and what they're testing for. They are not testing for all of the substances that he was positive for at the time of the crash. So the test that they're using will not detect, I believe, fentanyl and maybe morphine. So they can do a 14-panel instant test. They typically only do the 5-panel, and then the alcohol test. I would ask that the court amend the bond conditions if he is going to remain out on bond, that he be required to do the 14-panel instant test and the alcohol test, and that it be on a regular instead of the random call-in, basically no less than 3 times a week, because these types of substances will typically remain in a system for up to 72 hours. If we do the 3 times a week testing, we should be able to monitor it pretty safely. So with that, I leave it to the court's discretion. Thank you.
All right, before you speak, Mr. Marcoux, let me say one more thing. One of the concerns I had is that you were in custody from December 2nd You posted bond on December 13th. So you were in custody for 11 days. The test that was positive was on December 16th. So it'd be 5 days after you got out of jail, you tested positive for methamphetamine. Let me look at it again, and amphetamine, I think. I keep having trouble finding that DRC file. Now, that isn't evidence at this point. And the concern was that there's no testimony or evidence regarding that, but based on our knowledge from dealing with these sorts of things on a daily basis, methamphetamine doesn't stay in your system for 15 days. So the obvious concern was, and my concern and Mrs. Davis's concern is, you got out of jail after 11 clean days and immediately relapsed. What you're charged with is driving suspended with a death, which is a 15-year felony. As a habitual felon, makes it punishable by up to life imprisonment. In my mind, it's worse if you're intoxicated or under the influence of drugs causing a death, but it's the same offense. It's a 15-year felony. The time I set your bond, I didn't know whether you had alcohol or methamphetamine or, heaven forbid, fentanyl in your system. So the concern is that between the time you got out and the time you tested 5 days later, you'd started using again. And that is our concern. Mr. Markku?
Your Honor, I would ask the court to consider following the, for want of a better phrase, game plan that Ms. Davis outlined for the court. He's ready, willing, and able to test right now. I am optimistic he'll test negative for all controlled substances. If he does not, then I understand the court's decision to revoke and Ms. Davis's request to revoke. He has been attending AA, NA. I have proof of that. He has been calling the day reporting center every day since then to be able to test, but for whatever reason, because it's random, his name has not come up. I've also confirmed that in fact, he has not been driving to work. He's been getting rides from co-workers and otherwise. So I would ask the court to consider that particular plan. And obviously, what I told him this morning was if the court were to give him any consideration and not revoke bond, that he would have to test more frequently. The test would be broader spectrum than it currently is. And that if he is either, if he doesn't test positive or is found driving, that at that point, the expectation would be that his bond would be revoked no matter what. There wouldn't be much argument on either way. So that is my proposal at this point. He understands that there has to be a short sanction. My concern, Your Honor, and it's not, I don't know if it's a legal argument. I don't know exactly how to phrase this, but it's disturbing that somebody signs a bond condition that talks about testing positive. You get 24 hours, 48 hours. It almost gives a sense of like a, I don't want to say a pass, but it basically gives somebody notice that this is what's going to happen to you if you test positive. And unfortunately, it can possibly create a risk that somebody thinks that's all that's going to happen to them.
Well, that's an old form.
Yeah, and I think we need a new form on this case.
And it doesn't have any due process, you know, if there's a problem with the test. Well, first of all, let's see whether we've got somebody to do an instant test. All right, we've got somebody that can do an instant test on Thomas Logan. That's fine. It's casual post-Christmas, but so are Dan or Matt there? How are you gonna do it? That's for fentanyl and methamphetamine. All right, well, let's try that. All right, thank you. All right, bye.
Your Honor,
Yes.
just to clarify, what is the level of testing that we have here? Is it
Well,
just
all
the
we have
5?
right now are the instant tests. If you want him to go to the day reporting center and come back, we're gonna sit here for an hour.
No, and I guess what my thought was is we do whatever instant test we have here,
Mhm.
assuming that that is negative for substances. I would still ask that he go and test at DRC with a 14 panel
Okay,
today so that we can get him on a more regular schedule.
all right.
Thank you.
Mr. Logan, this is very serious business. This is essentially a homicide case. The maximum punishment is up to life imprisonment. And the facts are terrible. The closer you look at it, the worse it gets. There's a lot of public interest. There are a lot of families that have interest in this. Everybody at the school, everybody in that neighborhood. And so the feeling is if you're gonna be out on a substantial bond and just using meth, we might as well just cancel your bond and let you sit. When bond is canceled, in theory, the prosecutor has to bring the case to trial within 90 days or a bond needs to be set. General rule in a felony case is if the defendant's unable to post bond after 180 days, they're entitled to have a bond set. If bond is denied, you're entitled to either have a bond set or have the matter tried within 90 days. When I was prosecutor, I used to welcome it. I say, yeah, we'll try this in 90 days. But it's not always possible in this kind of case. They're awaiting laboratory reports regarding substance abuse. They're awaiting probably autopsy reports, accident reconstruction reports. These kinds of cases can take time. And because of the seriousness of it, the prosecutor charged this most apparent offense, driving with a suspended license, immediately, thinking they'd wait until the other stuff comes back. So I'm going to send you out with Ms. Kiefer from the probation department. We'll do an instant test. Your test for methamphetamine is going to be negative. Is that correct?
Yes, sir.
When did you learn that your test was positive?
Thursday, I believe, last week.
Right now, I'll just leave it at that. The last thing you need in your life right now is methamphetamine, closely followed by fentanyl. That's a fairly recent phenomenon where they're combining a powerful stimulant like methamphetamine and a very powerful depressant like fentanyl. That's why we have so many people dying. All right, I'll suspend the record here for a moment. You go here in the back. All right, we are back on the record. Ms. Kiefer, thank you for your help. How do we do with the instant test?
He was negative.
All right, very good. That test for alcohol and or
It
methamphetamine?
does not test for alcohol, it does not test for fentanyl, but it does test for everything else. No, well, it will test for benzodiazepines, it'll test for cocaine, methamphetamine, marijuana, amphetamines. It is a 10 panel, but it is not the extensive because fentanyl is a bigger test.
All right, thank you. All right. So that's positive news. All right, Ms. Davis, in light of that new information, what's your position?
Your Honor, as I had stated to the court before, if he tested negative on the instant test, I would still like him to complete a 14 panel at DRC today. And I still believe that there should be some sort of a sanction for what has occurred. this is not just a minor bond violation. This is use of a controlled substance, which is a felony, a 10-year felony for possession of methamphetamine. So with that, I would ask the court to impose some sort of a sanction against him for this positive test, which was lab confirmed. It does seem that from DRC's information to me, they did not tell him on Monday, the 16th, that his test was a presumptive positive, that they instead just simply sent it to the lab and then intended to discuss it with him sometime this week when he came in to test again. That's something that I'm going to address with DRC so that we can maybe have a better process on this.
Well, yeah, they don't always know, and sometimes, very often, they wait for lab confirmation, which certainly delays things.
Right, so with that, I think to the court's discretion at this point. Obviously, if there is a positive on the 14 panel or any positives coming up in the testing, then we'd be seeking to cancel his bond. Thank you.
All right, well, okay, I don't have a problem with that. The problem is they're very expensive. Like $45 a test.
I believe that's 45 for either one of the ones that DRC is using right now.
And so right now, the bond just left it randomly, and they did it randomly. 3 times a week would be about $150 a week for the next many weeks pending circuit court. So that is an issue, but Mr. Logan, you're still employed, correct?
Yes, Your Honor.
Now, my recollection was that you live near Vicksburg. Where do you live?
Well, that house was broken into by people while I was in jail
Okay.
and demolished. So right now I'm residing between my grandfather's old house that passed and my buddy Tom's because my ride.
Which is where?
Galesburg and Climax.
All right, so they back to so it's a long way from Galesburg to Sturgis.
Yeah, I mean, I used to drive it all the time. Now I
Well,
just have to get a ride.
We haven't had a valid license in years.
I
You've been
understand.
revoked for 5 years, but it's to get a ride, it's 50 miles from Galesburg to Sturgis. But I have not received any information that you've been driving, and I think if you pulled up at your shop driving, the guys at the shop would rat you out.
Yeah, I would never.
So I don't have any information that you've been driving, but just the logistics of getting from where you live to where you work and testing in the meantime is daunting. So there's a significant difference between canceling your bond and ordering a sanction for a positive test. We order people not use drugs or alcohol every day, knowing that they're going to have a difficult time complying with those terms. People that are addicted to methamphetamine don't just stop using methamphetamine because the judge tells them not to. When I have a person that's on bond on a methamphetamine case, and I have a condition that says you don't use bond until I see you next time, it's like saying, hold your breath till I see you next Wednesday and don't breathe again until then. You have a very strong, powerful addiction. And I didn't know that there was a methamphetamine and or fentanyl component to this until I got Ms. Davis's motion. The charge was driving suspended with a death. There may have been some suspicions, and they called our office that morning for search warrants. And so my staff was dealing with it. And now I find that after doing 11 days in jail, within a few days upon your release, you tested positive. And that was on the 16th. Now it's 10 days later and you're negative. So we've got a baseline that you're negative. And I'm assuming you're gonna be negative for fentanyl and any other substances as well. This bond condition says no drugs. Drugs like alcohol are legal. Drugs like marijuana are legal. It's legal in Michigan for people to use marijuana if they're an adult for recreational purposes. Not while you're on bond. You can't use marijuana. You can't drink alcohol. You can't take any controlled substance unless it's prescribed by a doctor. You are presumed to be innocent until the state is able to prove otherwise, but you've been charged with a very serious crime. You're also presumed to be entitled to a bond. Under very limited circumstances, the judge have authority to do no bond. But there is an allegation that you violated the condition of your bond by using methamphetamine after you're released from custody. Mr. Marcoux, is your client prepared to speak to that?
Your Honor, I think because of the nature of the underlying criminal cases and the nature of the allegations and the similarity between the two, I think Mr. Thomas would be more than willing to do a no contest plea to the bond violation. I just don't want him saying anything else otherwise because of the similarity in the substances that are alleged. And if the court is willing to accept that, then we can move forward with the bond violation issue.
All right. Mr. Thomas, there's an allegation that you violated your bond by using a controlled substance, specifically methamphetamine. You have a right to have a hearing on that where the prosecution must establish, at least beyond a preponderance, that you use a controlled substance in violation of the court order. You could plead guilty to that, or you could also plead no contest. By pleading no contest, you don't admit what happened. You also don't deny what happened. And I would use the laboratory report from the Day Reporting Center as evidence that you were positive for methamphetamine. Are you willing to plead no contest to that charge?
Yes, Your Honor.
All right. I'll accept that and use the lab report for the factual basis. What's your work status right now? Are you shut down between Christmas and?
No, I worked yesterday. I worked 7 days a week. I work New Year's.
You work Christmas Day?
Yeah, it's livestock, so they don't know it's a holiday.
A good point. I didn't realize that was what do you do?
I'm a manager for a pig farm.
How many different pig farms do you manage?
Well, we got to do a test because someone messed up at one of the ones while I was gone and broke biosecurity, but 2.
Where are those farms?
One of them's on Nottaway Road and one of them's on Featherstone.
For some reason, I thought it was a manufacturing plant. Yeah, cows and pigs don't take Christmas off. The dairy farmers are 24/7, 365. Let's talk for a minute about what our plan is for January 7th. That would be the pre-exam conference. And I presume by that time, the amended complaint will be filed.
Yes, at least as to the OWI portion, it just depends on what comes back from CCU and the accident reconstruction report, if there is going to be a reckless causing death, but.
Well, that could take
It could
weeks and
take,
weeks and
yes.
weeks.
So I've at least discussed that with Attorney Marcoux, so he's aware.
Well, they're all the same maximum punishment, 15 years as a habitual. In my mind, obviously operating while intoxicated with a death is a more serious charge than operating while suspended with a death. But, and then reckless, in order to prove that you're operating while intoxicated, they'd have to prove that you were intoxicated or at least impaired by the controlled substance. The fact that there's a controlled substance in your system doesn't necessarily establish that you were intoxicated by it. And I don't yet know what those results are. But you've got competent counsel. The prosecutor is all over this. She was on it from the first day, fortunately. And So we'll see. I'll be the judge that'll be shepherding this forward. I believe January 7th is
The conference date, Your Honor,
pre-exam date.
and when is the examination?
Theoretically, it would be January the 14th at 1.
Okay, understood.
All right, now you dodged a bullet in that your bond isn't canceled, but you got weaned because you're going to jail for 24 hours starting right now. Someone's gonna have to tend the pigs. 1 day credit 0 for your bond violation, leaving 1 day to serve. I didn't want to set up a weekend. The jail isn't accepting weekends. There should be some immediate sanction for this. So the next one could very well result in the revocation of your bond. All right, I'm also going to amend the bond that you need at least 2 14-panel tests per week. And I will see everybody on January the 7th.
Thank you, Your Honor.
Your Honor, I am triple booked on the 7th. I believe that Ms. Davis and I can conduct a conference by phone or otherwise. In the meantime, I'm expecting that.
I'll be fine. You have both got and to your defense, you just got in it.
I've gotten the reports. The prosecutor sent me everything last week. I've already started reviewing them. I'm thinking about, what we might be doing moving forward. Ms. Davis will communicate the offer to me before or around the 7th, and then we'll decide whether or not we'll have a hearing on the 14th.
Very good. Thank you.
Thank you, Your Honor.
Violation.
Yes, yep. All right, Mr. Fleming, thank you. Everybody is back. It's time to start this arraignment. This is called a bail setting arraignment. Sometimes we refer to them as jail arraignments, but it's to get the case started after your arrest, advise you of the charge, and set a bond. The prosecutor filed a complaint this morning, I think, alleging that on or about Christmas Day, December 25th, you did assault, batter, wound, resist, oppose, or obstruct Nathan Johnson, Brian Freds, and Joshua Edgington of the Sturgis Police Department. Those are all felonies punishable by up to 2 years imprisonment. It's also alleged that you are a habitual offender with at least 3 prior felony convictions, making this a 4th offense, which on a 2-year, I believe, makes it a maximum of 15 years imprisonment. Prosecuting Attorney-elect Deborah Davis is here with us, and you met with the public defenders, Keith Stickley, the chief public defender, and his assistant, Larry Westcomb. Ms. Davis, let me ask you this. The bond information sheet refers to a fleeing and eluding incident earlier in the day. There's no fleeing and eluding component to this.
Your Honor, there is a warrant request for fleeing and eluding from Officer Joshua Wired from the Sturgis Department of Public Safety that is in review. There were some questions about jurisdiction and other charges that may be associated with this. There was an incident in Sturgis, which is what brought the police to the place where he lives, and he then was seen in his vehicle. And there are 4 separate jurisdictions that have potential fleeing and eluding charges, all from yesterday's incident, which is why I'm here to advocate for some bond conditions and potentially not allowing bond in this case because of the danger to the public that this individual presents. So I don't know if you want me to go into that.
Go right ahead.
Sure. So this particular defendant was just released from parole recently. He was on parole from an incident of resisting and obstructing, causing injury to an officer here in St. Joseph County. He has several prior domestic violence charges, including domestic violence 3rd and a strangulation. He has been charged with absconding previously because he hasn't appeared. And his behavior yesterday is extremely reckless and dangerous. This started in the early afternoon. It's alleged that his significant other, who was the victim of one of his prior domestic violence charges, had called the police to assist her because he was being violent and breaking things at the home. And she alleged that he is using methamphetamine again since he's been off of parole for a few weeks. So with that, the officers waited to see if he would come back because she said he had left driving erratically. He did, in fact, pass by the officer on Nottowell Road going 100 miles an hour in a 45-mile-an-hour zone. It's alleged that at that time, Officer Wired did pursue the defendant, but that pursuit went through multiple townships and the village of Baroque, and then into the state of Indiana, where it had to be terminated. Shortly thereafter, it's alleged that LaGrange picked up, they found him, and he then fled from the LaGrange officers back into Michigan. It's alleged that they then lost him again, and then he went back into Indiana and then came back to Michigan, where St. Joseph County deputies found him and pursued him, where they lost him again. And then Officer Wired in the Baroque Township found him again and pursued him. But because of his driving being so dangerous, passing people on the right side, that sort of thing, they terminated the pursuit. And then a tip led them to find him last night in Sturgis at the American Inn, which is where this RNO ×3 was alleged to have occurred, because he refused to come out of the hotel room, physically was holding the door shut, preventing the officers from unlocking the door. And then they found him in the bathroom, again, not coming out with the officer's lawful commands. So as far as the danger to the public, I think as far with his driving and the issues, he does have a valid license, which is surprising based on the fact that he has 3 prior OWI incidents in different states. He has criminal history in several different states, including a flee and elude in West Virginia, and some incidents in Indiana, multiple different instances of use of controlled substances and assaultive threatening behavior, multiple prior assaulting, resisting, obstructing of police officers, although some of them were dismissed as part of plea agreements. He is an extremely dangerous person in the view of the prosecutor's office, and we would ask that the court consider not allowing a bond at this point because of the danger to the public, as well as the likelihood that he is not going to appear. And if he doesn't appear and a bench warrant is issued, it could be an extremely dangerous situation for the law enforcement involved, as well as the public, if they have to go out and chase him and find him again. Again, there's also going to be at least the flee and elude from Sturgis that is under investigation because of the potential for the methamphetamine, potential for an OWI or OUID. There was some further investigation that was supposed to take place this afternoon. I'm not sure of the status of that yet. So we went forward with just authorizing on the resisting and obstructing, which we're prepared to have a trial on those pretty quickly. If the court wants to set it quick, we can. I would rather have this individual stay in custody and not be able to have access to vehicles or substances so that we can have a trial sooner rather than later. And because he is a 4th habitual, the fleeing and eluding will likely be a potential life offense.
All right, and the fleeing and elude could be a 5-year with a 4th habitual. Mr. Fleming, the public defenders are here with you. Let me ask you a couple questions. I show your address as North Street, Sturgis. Is that correct?
Yes, sir. Yes, sir.
All right. So the room at the American Inn, Mr. Mr. Cannon's room, you didn't reside there. You just happened to be there.
Mr. Fleming, I'm going to advise that you not answer that question. All right. Your Honor, we would ask that the court respect Mr. Fleming's right to stand mute, have a not guilty plea entered on his behalf.
All right.
And then we have we would have a brief, I guess, rebuttal in terms of bond.
All right, Mr. Fleming, in interest in protecting any of your rights, the public defender's recommendation is you don't say anything. And some of it may be moot because I'm going to deny your bond. So there's no point in asking whether you're employed, I guess, or where you live. I'll speak to the reasons for it here in a minute. But Mr. Stickley's advice is probably wise. So at this point, I'm going to show you stand mute, plead not guilty. I'm going to appoint an attorney for you. I'm going to set a pre-exam conference for January 7th of 2025 at 8:30. Pre-exam conference for January 14th, 2025, if needed, at 1 p.m. Mr. Stickley, what else would you like to place on the record here?
Your Honor, the only other thing that I had to place on the record this afternoon is that the defendant understands that the court might have reservations about what kind of bond might be set. MCL 765.6 does lay out that the defendant would be entitled to bond and that bail shouldn't be excessive if not addressed by some other statute. On the list of no bond acts, allegations in Michigan, I'm not sure that this qualifies as a no bond.
I had a concern that a 2-year R&O would qualify for no bond. So let me look at the rule. But go ahead.
And that is my statement, Your Honor. I was not able to find where resisting and obstructing an officer was one of the enumerated no bond conditions as referenced. I know the general overall rules MCL 765.6. I was trying to find, as you know, it's broken out a little bit helter skelter. But
yes,
I don't believe that is a qualifying offense to a no bond condition.
all right. This happens a lot. The courts will set a bond at $1 million. And what they really want is they don't want the person to bond out. So rather than say no bond, they set a very high bond. That's somewhat disingenuous. The legislature is working on some bail reform statutes that I don't think got over the hump at the end of the last session. And talking about eliminating different types of bail. Anyway, the case is aggravated. You're a very angry young man, have been for some time. I'm not sure everything that's going on here recently, but you have several previous assaultive offenses. 2013 assault, great bodily harm, bound over to circuit court. 2014 809 FY, 2 counts of resisting and obstructing, bound over to circuit court. 2014 941 FY, absconding on that R&O charge, bound over to circuit court. 201920 assault, great bodily harm, felonious assault, resisting and obstructing with an injury, and fleeing and eluding. That was bound over to circuit court and you went to prison. That's the one you're on parole, just got off parole on. File 201972 was a domestic violence third offense felony charge, bound over to circuit court. You had an assault and battery and MDOP in my court in 2021, I think, while the other case was pending, and you never ended up paying the fine and costs. Ms. Davis also indicated there's some out-of-state charges, including a fleeing and eluding in another state. The resisting and obstructing here is not that egregious. You went into some other guy's hotel room and wouldn't open the door for the police. It's like a child hiding their head under a blanket thinking maybe nobody would see them. And then it read like a bad movie where you're hiding in the shower. They should have turned the water on. Anyway, that's how you finally got arrested, and they were resolute in their attempt to take you into custody. The reason that I considered, well, all of this stuff, but there are more charges coming, and it would be not a great situation to have you bond out on this and immediately get rearrested on some new charges. So my intention was to deny the bond, at least until the time of the pre-exam conference on January 7th, and see what else gets charged. Which would be more honest than setting a very high bond that you couldn't post. But Mr. Stickley pointed out a fear that I had. There are certain cases you can deny bond for, and I'm not certain that the actual facts of this case, where you wouldn't open a hotel room door, generally wouldn't merit a denied bond. You've got a bunch of baggage in your past and a bunch of baggage in your future. But there's good reason, public safety reason, to not let you bond out pending the new charges. So we will set a bond as Mr. Sickley requests. Bond set at $200,000. Cash or surety. This sounds like methamphetamine with a capital M, but we'll see how it plays out. I'm glad no one was hurt. Yes, sir.
There's no drugs involved.
All right, well, that's a plus. Just anger, I guess. And you and I've discussed it. You're angry. So, I mean, you drew a crappy hand, I'll grant you that, but this isn't the way to resolve it. Billy Joel wrote a song called Angry Young Man. I used to have the lyrics, had the lyrics taped inside my briefcase when I was in law school.
You remember me when I was a kid?
Yes, I do. I remember your brother and your sisters. That's what I'm talking about. You get
brother. I don't have a brother. I got a sister that was molested. Now
yes,
you
I
remember?
remember. I was the guy that prosecuted the case.
Yeah, I know you was. You was the one that let him off.
I didn't let him off. He ultimately was convicted. He was acquitted in the first case, and we had a second one. That was almost 40 years ago. And no, I didn't let him off. He ultimately, I believe, went to prison.
No, he didn't. You let him off. Child molestation.
All right,
You let him
All
go.
right.
let's
all
hold tight.
right. Anyway, we'll leave that song lyric for another day. No drugs and no alcohol. No driving. Test if directed. I don't think you're gonna bond out. We'll see what comes of these new charges. Yes, Mr. Fleming, I remember when you were a kid and you got a lot of pent up anger you're still dealing with. All right, sir, I'll see you on January 7th. Your attorney will come out to the jail and see you.
Thank you, Ron.
Thank you. The line goes, I believe I've passed the age of consciousness and righteous rage. I found that just surviving was a noble fight. I once believed in causes too. I had my pointless point of view, but life goes on no matter who was wrong or right. I'm gonna put that last part on my tombstone. Life goes on no matter who was wrong or right. He was very young. I still have that briefcase in the attic. I think that typed out thing is still taped on the inside of it. Good afternoon once again, Mr. Watkins.
How you doing?
I'm doing good. We talked this morning about your Indiana charges in LaGrange. I didn't
Yeah,
have
can
the
you-
paperwork in front of me at that time.
Can
And
you
you had
explain to me what
indicated
it is?
you were, well, I'll tell you what I know, which ain't much. You are wanted in LaGrange County, Indiana on the charge of residential breaking and entering. Let me see if I can see anything else about it.
What, like, is that from how long ago?
Well, let me see if I can see. The out-of-state warrant says that you failed to appear in court on October 7th of 2024. Warrant without bond has been issued. We are commanded to arrest Joshua Watkins and hold him for LaGrange County. The Indiana complaint number is file 21. So it makes it look to me like there was a 2021 incident. And they allege that you failed to appear in court on October 7th.
Okay, so it's like a parole violation.
That's what it sounds like.
Okay.
All right, now are you willing to go back to Indiana to deal with that?
Yeah.
All right, let me read you the language that has to do with waiving extradition. I, Joshua Dwayne Watkins, am the person wanted by LaGrange County, Indiana on a pending warrant charging residential breaking and entering. I hereby waive the issuance and service of a Michigan governor's warrant and all other procedures incidental to extradition proceedings, including the right to an attorney, unless I have already retained one. I agree to voluntarily return to the demanding state of Indiana in custody of an agent of that state. You agree to that?
Yeah, will I be given do you know anything about me getting another lawyer or anything like that?
Yeah, that'll happen once you get down in Indiana. This is just ministerial up here. We're just doing administrative. There's a warrant from another state. You got taken into custody in our state. If you're willing to waive extradition, they'll just come get you. And this is just LaGrange County, so it's the next county south. If you're not willing to waive extradition, the Indiana governor has to write to the Michigan governor. And then they do this governor's warrant, which is sometimes known as an extradition warrant. They have a certain amount of time, generally 90 days to do that. But the best way to deal with this is to just get back to Indiana and address it there.
Yeah, I ain't trying to wait 90 days for this. I want to get this shit over with.
All right, well, they're gonna send this thing out to you and you'll sign it and you're good to go. All right, Mr. Watkins, good luck. What I did say on your sentence this morning, that when Indiana's ready to come get you, you can go to Indiana. So I'm not gonna make you wait and sit here for 21 more days or whatever was left on that. So
I'll be done with it, right?
yep. All right,
Okay.
good luck, sir.
Thank you.
All right. So, Mr. Raymer, want to come on up? All right. So, Mr. Sears, you're not yet on my list. So, I'm going to need your P number real quick. So this is in the matter of the people of the state of Michigan versus Shane Leroy Raymer. Leroy or Leroy?
Leroy.
Yep, okay, I like Leroy. File number 23-21665FH. I have Brenda Underwood, P 41009, appearing on behalf of the defendant, and state your, I have Dan Gumto, but state your full name and your P number, please.
Your Honor, Nicholas Sears will be at people. Nicholas Andrew Sears, I am appearing under Michigan Court Rule 8.120, I believe, which is the observation of waiting for my bar results.
Okay, very good. All right, you had your hand up?
Yes, I fired her due to misrepresentation
When did you fire her?
over 2 weeks ago.
Was that in front of me?
No, that was in her office but the reason I fired her,
Well, do you have another attorney?
I will represent myself.
You're gonna represent yourself. You know, there's a very famous quote about representing yourself. Do you understand that?
Yes,
That, you know, do you have a law degree?
I don't need a law.
Do you have a
degree.
college degree?
I don't need a law
Did
degree.
you graduate from high school?
I don't need that either.
You don't need that to represent yourself? Okay, do you have access to, okay,
I
so,
have evidence that shows that the description did not match and
well, I'm not gonna get into that yet. So you're asking me today to remove Miss Underwood as your attorney,
yes,
and you wanna represent yourself.
if I.
Do you understand that even when I have court cases, I hire an attorney to represent me?
Well, I can't trust anybody in this system in this area because they all seem to be working together. This case should have been resolved a long time ago during the appeal the first time. She should have objected when the claim was made that I matched that description 100%.
Okay, so Mr. Reamer, part of what you're saying shows to me that you don't quite understand how the court procedures work, okay? So your attorney has an obligation to ethically represent you. And so before, I would have clients come to me and say, I want you to file this and I want you to file that. And I would say, there's no basis for that. And I don't file frivolous motions, or I would say to them, they have probable cause or whatever. So if you want to represent yourself, you can do that at your own risk. You have the right to represent yourself. But what I will tell you is that Miss Underwood is the bane of most prosecutors' existence, because she's a little pit bull and she doesn't put up with a lot of guff from them, and she's a tough defense attorney. So you may not like what she says, but I feel like she's always honest. So that being said, if you want to proceed and represent yourself, you can. But you understand you're going to have to file written motions. You're going to have to follow the court rules.
This is the trial, right?
No, it's a pre-trial.
How is this not the trial? I was told this is gonna be the trial.
This
I'm
is a,
supposed to be facing it. I'm supposed to be sitting here with a jury today.
no, you're not.
Yes,
You're,
Your Honor.
Mr. Raymer, I schedule jury trials and I haven't scheduled you a jury trial.
I was.
Yeah. Oh, wait, you're the one that didn't show for the pre-trial. That's why. Is that why?
Your Honor, if I could speak
Yes.
for a second, I think the first thing we need to do.
I'm
is
sorry.
address the bench warrant.
Yes. So, Mr. Raymer, you
Mr.
failed,
Raymer this morning.
yeah, he failed to appear for the pre-trial conference.
That's correct.
All right. So everybody stop talking for a minute. So Ms. Underwood, thank you for reminding me of that. Mr. Raymer, you had a final pretrial conference on December 11th, and we gave you a notice of hearing, and you failed to appear for that pretrial. And because you failed to appear for that pretrial, I canceled the jury trial because it cost me a lot of money to have a jury here. And so if you're not here for the final pretrial, I'm not going to trial until I get you here. So I actually issued a bench warrant for your arrest for failure to appear for the pretrial. Do you understand that? So Ms. Underwood's now asking for me to set aside that bench warrant. Is that what you said?
Thank you, Your Honor. He did demonstrate to the court that he can show up by showing up this morning.
Okay, so Mr. Raymer, so Ms. Underwood's asking me for me to set aside the bench warrant for your failure to appear on December 11th. Do you understand that? Speak.
Yes, ma'am.
All right, and Mr. Sears, any objection to me setting aside the bench warrant since he has it today?
No, Your Honor.
All right, so Mr. Raymer, I will quash that bench warrant, and I'm sorry, I didn't look back to see that this was the original trial date. So that's my procedure. If people don't show up for a pretrial, I set the jury trial as the pretrial, okay? Do you understand that? So that's why
Yes or
there's no
no?
jury.
Yes or no?
I did answer that.
So we're recording, so we have to hear you. So you have to speak up really loud, okay?
I said yes, ma'am.
Louder.
Yes, ma'am.
Okay, so Mr. Raymer, all right. So Miss Underwood and Mr. Sears, this is a date and time set for pretrial. Mr. Raymer, I have your attorneys did file all the paperwork. Miss Underwood, do you want to speak to Mr. Raymer for a moment?
Your Honor, I'm not sure that would do any good.
Okay. So
If Mr. Raymer would like to speak to me, I'm more than happy to speak to Mr. Raymer at this point.
So I'm going to quash the bench warrant. Mr. Raymer, if you want to sit down and talk with Miss Underwood and see if you can meet a common ground, I would highly recommend that. You know, if you want to take 5 minutes or 10 minutes and talk to her, you can do that.
She's not been representing me appropriately.
All right, so do you understand you don't get another public defender?
Well, I fired her and I talked to this man. Are you Mr. Glacier?
No, that's Mr. Glazer.
Who was it that was in the office with us?
That was
Mr. Malero.
Okay, Mr. Malero and her, why was he in the office when?
Because he's
in the,
all right, so Mr. Raymer, if you are firing Miss Underwood, or I can grant that, but I don't have the ability to appoint another public defender to represent you.
No,
They are a separate entity.
If I can't get somebody to represent me that's doing the job appropriately, then I will represent myself. Because I can prove that I was not that person that they're claiming.
That's what a jury trial's for.
Yeah, and when it comes to the jury trial, then I will take care of it there. But I don't need somebody that's not gonna represent me appropriately.
Okay, well, I really doubt that she isn't appropriately representing you, but so Mr. Glazier and Mr. Malaro, he's asking for me to fire Miss Underwood, so
If I may, Your Honor.
yes.
Your Honor, I vetted Mr. Raymer's claims about Ms. Underwood's representation. My understanding, she conducted a preliminary examination. She also filed a motion to dismiss, I believe, that was heard and ruled on by this court. I've not determined that she's done anything that did not require, or that was not required of her. And so I denied Mr. Raymer's request to appoint a new attorney. For one of the reasons was that a trial date was imminent and it would be almost impossible for any attorney to get up to speed. Ms. Underwood is clearly ready to go to trial on this case. I think, as the court, I think, is aware, Mr. Raymer just doesn't like what he hears. So that is the reason I denied his request to have another attorney appointed in this manner, because Ms. Underwood's doing everything she can do on his behalf.
So Mr. Raymer, I guess I would ask, she held a preliminary exam, which is what you do to dispute the charges. And the judge ruled, whoever heard this, that there was probable cause and bound you over, right? Yes.
Yes, Your Honor.
And then she filed a motion to dismiss, is that correct?
Yes, Your Honor.
And I denied that.
Yeah, because you was.
What else is she supposed to do?
You was given false information. All she had to do is object and let it be known that I did not match the description of the person.
That's for a jury to decide.
No, that's for the.
Okay, well, I'm glad that you were trying to explain the law to me. So if you do not want her as your attorney, I will remove her
Yes,
as your
I do not
attorney.
want her as my attorney.
All right, so Ms. Underwood, you are relieved of your duties. So Mr. Raymer, you can either hire an attorney or proceed as you are. So I will get another jury trial date. Mr. Raymer, you will need to file with the court jury instructions and voir dire questions. And those are going to need to be filed by a certain date.
And how do I go about doing that?
I can't tell you because I can't give legal advice. That's why you had an attorney. So you're gonna have to figure that out on your own.
Okay. Well,
I can't give you legal advice as a judge.
That's all right.
That's what Miss Underwood was for.
But she wasn't doing her job.
She did do her job.
No, she
But
failed.
I'm not gonna argue with Mr. Raymer. So Miss Adams, I'm looking for a trial date.
Judge, you want me to find the first available?
He's not in custody. It's a one-day trial, so sure, but he's not in custody, so.
First available is April 22nd at 9 AM.
Does that work for you, Mr. Sears?
Your Honor, that does work for the people.
All right, does that work for you? Okay, so I'm gonna set trial for April 22nd of 2025 at 9 AM. And I'm gonna set a final pre-trial for Ms. Adams. Do I have April 9 available?
Yes, Judge.
So a final pre-trial for April 9 at 8:30 AM. So was there a plea offer made in this file, Mr. Sears?
Your Honor, yes, there was. Would you like me to place what the offer was?
I always do, yes. I keep that in my file. Thank you.
You're on.
You're not on this file anymore. Thank you.
Just 1 second while my computer, it is slow, Your Honor. It looks like the final plea offer provided from my office was 2 counts of an attempted RMO.
All right, so Mr. Raymer, do you understand the plea offer was to plead to 2 misdemeanors?
Yes, sure.
Okay, so those are 1-year misdemeanors, so it'd be 2 1-year misdemeanors in lieu of the 5-year felony, because you have, well, 4-year felony, police officer assaulting and resisting causing injury, and you have 2 2-year felonies for police officer assaulting, resisting, and obstructing, and 1 misdemeanor for disorderly person. Are there any body cams? Were those provided to Mr. Raymer?
Yes, I believe a discovery was sent to obviously the public defenders.
Okay.
If you would, obviously you would need any additional body cams or discovery, we would ask that Mr. Raymer come to the prosecutor's office and receive any discovery that he would want in person. Call ahead and they can get a file.
Okay. So I'm gonna set the final motion deadline for 4/9 of 25. And then motion in limine for the same day as well. Jury instructions and voir dire questions will be due by April 2nd of 25. And so those must be filed with, you must provide a copy to the prosecutor's office of your voir dire questions and jury instructions, and a copy to the court on the 3rd floor of the clerk's office.
And that can be wrote out on a blank piece of paper?
No, they must be provided in full and filled out.
Okay, where would I go to get those forms?
There, you can do research on the computer. I mean, this is why, Mr. Raymer, when you're dealing with a felony and you're facing trial,
Yeah.
it's important to have an attorney. And it
Yes,
doesn't
one
sound,
that's doing their job, yes, I understand that.
well, you haven't presented anything to me that says she hasn't done what she's supposed to do so far. So, Mr. Raymer, you know, there's no legal services available for indigent defendants other than the public defender's office. And, you know, you could hire an attorney, but these things are required. If you don't file them, then you don't get to add them the day of trial. Do you understand that?
What's that, the evidence? I don't get to add any evidence during the day of trial?
Well, you must submit it as exhibits and witness lists. Have you got to exchange those with the?
All the body cam would be considered already submitted, correct?
So you have to provide witness lists and a list of exhibits to the prosecutor's office, to my office, and then you must provide copies of that to them.
And where do I find your office at?
3rd floor clerk's office. Okay, but then you have to provide a copy to the prosecutor too.
Yeah, I'll
Okay.
probably head over there for you.
But by law, Mr. Raymer, I can't give legal advice because I'm a judge.
Yes, sure.
Okay. So, Ms. Adams, could I please get a copy of this from Mr. Raymer? And I'm gonna put little asterisks next to everything. Okay, so could I get a copy from Mr. Sears as well as for Mr. Raymer? Ms. Raymer, again, here's, do you want Mr. Raymer's file? Are you sure you do not want to proceed with counsel?
I would prefer to have counsel, but I don't want her representing me.
Okay, well, that's your choice. but your other option is to hire someone. Thank you. All right, have a seat back there and we will get you a copy of your pretrial notice. Okay, Mr. Madison, I'm sorry, I put you in the waiting room because booking is always kind of loud. All right,
Yes,
so
ma'am.
this is in the matter of, it's our pickup. This is in the matter of the people of the state of Michigan versus Brandon Madison, file number 23-21242 FH, 24-21996 FH, and 24-21997 FH. I think your dad was here earlier, but it's been a long morning, Mr. Madison, so I'm sorry. So I am covering this file for Judge Olsaver. So,
Okay.
Mr. Madison, we have a motion affidavit and bench warrant on each of these files, a contempt of court for failure to appear for a probation violation hearing on December 11 of 24. That contempt of court can carry up to 93 days in jail. Do you understand that?
Yes, ma'am.
All right, and then the underlying request and summons for probation violation alleges that on November 12th and 19th of, I'm trying to find my little post-its. Judge Olsaver keeps track of his files differently than I do. You failed to report to the probation department on November 12 and 19 of 2024, and your whereabouts are unknown. So do you understand that's the allegation against you for a violation of probation?
Yes, ma'am.
All right, now on file number 23-21242 FH, you're on probation for police officer assaulting, resisting, and obstructing, causing injury. So if you plead guilty or found guilty, you could be facing up to 4 years in prison. Do you understand that?
Yes, ma'am.
All right, and then Judge Olsaver's files are much better organized than mine. Okay, and then on file number 24-21996 FH, you have the contempt of court that carries a maximum penalty of up to 93 days in jail. And then you have the violation of probation for, oh, no, that is a failure to appear for a pretrial on November 27th of 24 at 8:15 a.m. So that's a contempt of court for failure to appear, and that carries up to 93 days in jail. Do you understand that?
Yes, ma'am. Miss Angelo, all this stuff extends from like, I got sick, I can call it COVID, right?
Mr. Madison, hold on a minute. I gotta go through and
Okay.
read you your rights, and then I gotta
Okay.
go through and find out who your attorney is. So then on file number 24-21997 FH, we have a couple things. One, we have a failure to appear for a pretrial November 27 at 8:15 in the morning. So that carries up to 93 days in jail. And then we have a contempt of court from Darren Coast, my pretrial services coordinator, that states that you failed to drug test on October 22nd and October 29 of 2024 for pretrial services coordinator. And that you, when they tried to reach you by phone, they were not able to, and your voicemail was not set up, so they were not able to leave a message, and that's another 93-day contempt of court. Do you understand that, Mr. Madison?
Yes, ma'am.
Now, Mr. Madison, who is your attorney on your new felony files?
It's Matt Murphy.
Matt Murphy. All right, Mr. Murphy, do you represent Mr. Madison on those files?
Your Honor, I do represent Mr. Madison on the new felony files. I'm sorry, I wasn't paying attention to why we're here today.
You weren't paying attention to me, Mr. Murphy?
I didn't have any cases left scheduled, but yes, I have Mr. Madison.
All right, so we have contempt of courts for failure to appear for November 27 pretrial, as well as failure to drug test with Mr. Coast. And then he has a VOP on a previous file that he's on probation for. So, Ms. Underwood, perhaps Mr. Murphy will just handle these for you.
I'm sorry.
Mr. Murphy, do you want to handle Mr. Madison today?
Yeah,
So that Ms. Underwood?
Yep, I can handle these.
Mr. Murphy's going to cover these. Thank you, Your Honor. Thank you, Ms. Underwood. All right, so, Mr. Murphy, so we have a contempt of court on each file for failure to appear. And then we have a contempt of court. Two of them are failure to appear for a pretrial. One is failure to appear for a probation violation hearing. Probation violation is for failure to report. And that's on a 4-year felony. And then failure to drug test with Mr. Coast on the new files. So Mr. Murphy, do you, Ms. Adams, can you email that paperwork to Mr. Murphy maybe?
It's done, Judge.
God, she's amazing. So, Mr. Murphy, do you want to break out room with your client?
If I could, Your Honor.
All right, we're back with Mr. Madison. So, and Mr. Murphy, this is a Judge Olsaver file, by the way. I know I had one this morning. So, Mr. Murphy, have you had a chance to speak with Mr. Madison?
Yes, Your Honor. And speaking of Mr. Madison, because these are Judge Olsaver's file, we just asked the court to continue not guilty plea on them and set it for a pretrial in front of Judge Olsaver. And then Mr. Madison was asking to address bond in the matter.
Okay, the next available pretrial for Judge Olsaver is January 8th at 8:15 in the morning.
We could set it for that date and time, please, Your Honor.
Okay, is that right, Ms. Adams? He's back that day?
Yes.
Okay, all right, so Mr. Murphy, you may address bond.
Your Honor, Mr. Madison's cases before you right now, his failure to appears. He had been communicating with myself. He was texting my personal cell phone quite a bit, and then my number changed, and I tried to reach him through the office, reminding him moving forward, you know, with my number changing, you need to contact the steady number of the public defender's number. I haven't heard from him in a couple of weeks. He indicated, and we had expressed this before, I talked to Mr. Coase about this, that Mr. Madison had gotten sick. He believes he had COVID. I don't know if he's gotten the documentation to Mr. Coase, but since then, Mr. Madison had gone to the hospital again. He says they found a mass in his brain, and that there's more tests that have to be done to see if it's cancerous or not. Because of that, he has had some issues, focusing on what that means ultimately. He does apologize. He did have a lapse of memory in regards to making court dates. He has indicated, though, obviously he's available right now to test. If Mr. Coase wants to have a test arranged, he'll provide obviously a drug test sample right now to show that he has no illegal substance in his system right now. Again, Mr. Madison, in the past, we understand this is for not appearing. However, in previous cases that I've had Mr. Madison on, he's turned himself in when he's had outstanding warrants. On one of these cases, the newer felony, he had for an entire morning, the district court had wanted him to go over to the jail to get fingerprinted. He went over to the jail, waited for a couple of minutes. So it ended up taking a few hours of Mr. Madison's time running back and forth from the jail, then to APD, try to get something done. And again, he was following all the tasks at that point. So I don't believe that this is a matter of him trying to flee the jurisdiction. From my understanding, he was obviously, there wasn't a new charge that brought him into custody. The police went to his house and arrested him yesterday on Christmas Day. There wasn't a fight, wasn't a struggle, it wasn't any, from my understanding. Again, he didn't come to the court, turn himself in, but it wasn't a new charge. So I would ask the court to consider giving him a PR bond on these. He got on the date of January 8th to appear before Judge Olsaver. Again, he's available for testing if need be right now. So he's asking the court to consider is giving him a PR bond.
Mr. Coast, at any time was he in compliance?
No, Judge, he's been terrible at doing the drug screening. I actually set him up for drug screening on October 15th. He was supposed to see me every Tuesday, failed to do so. I've not seen him since October 15th. I actually been out to his residence before. He doesn't return phone calls. He did mention that he did have COVID and went to the hospital. I requested documentation. He has not done that. So because of his inability to follow directions, my suggestion is to leave the bond alone, and we could go before Judge Olsaver on the 8th.
All Okay, I'm gonna deny his request for bond and you can address it again with Judge Olsaver on January 8th at 8:15 in the morning. I don't believe, based on his activities in all three files, that I do believe he's obviously not gonna show up. So, all right, thank you very much, Mr. Madison. Judge Olsaver will see you back on January 8th at 8:15.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Darren James Earl Derringer, case number 2022 CR 329. Darren Patterson appears as defense counsel. Mr. Derringer appears from the Butler County Detention Facility Zoom location. Brett Sweeney appears for the state. This matter comes before the court at this time for hearing on a warrant to show cause alleging probation violation, including failure to obey the law resulting in conviction. On some City of El Dorado cases. Further violations that are alleged in this case would include failing to refrain from the use of alcohol or illegal drugs and failing to pay as directed. What announcement is made at this time regarding these allegations, Mr. Patterson?
Your Honor, after a review of the file and also email communication with Mr. Sweeney, I believe there is an agreement in this case that the court does not have subject matter jurisdiction, that at this time the case should be, the warrant should be withdrawn, the case should be closed, and costs, fees, and fines should go to collections.
What's the basis for lack of jurisdiction in this court, Mr. Patterson?
Your Honor, the basis is that on December 9, that was the end of the 1 year. December 9, 2023 was the end of the first year of probation, that the warrant to show cause was not filed at that time until January 3rd, 2024. That because of that, the court lost subject matter jurisdiction, that January 3rd, 2024 was outside of the 1 year and also outside of the 30-day additional time that's allowed. Because the court lost jurisdiction at that time, there cannot be a reinstitution of jurisdiction. Once lost, it's gone, and therefore the case should be terminated.
Right. Perhaps the dates that I've noted here are not correct. You're stating that the original probation period expired December 9 of 2023?
Yes, Your Honor. The original sentencing was November 9, 2022. The court did place him on a 1 year reporting probation. Therefore, the 1 year ended December 9, 2023, or I'm sorry, November 9, 2023. I apologize. And then with the 30-day additional time period for filing, it went to December 9, 2023. And of course, at December 10, the court lost jurisdiction, and that warrant at that time was not filed till January 3rd, 2024.
All right, I'm going to turn to Ms. Teal, the representative here from Court Services. Do you agree with these dates regarding the case status in this matter?
Your Honor, I've reviewed everything that Mr. Patterson's talking about, and it was the time that in October of 2023 to December of 2023, the court system was breached, and there was a lot of filing issues, and I think everything he is stating is accurate, and there was just delays in getting things timely file stamped and in the system during that time period.
All right, very well. Mr. Sweeney, on behalf of the state of Kansas, are you in agreement with the announcement that was made by Mr. Patterson and what he says the status of this case is?
I am, Your Honor. I had initially looked into the fact that there appeared to be subsequent show cause hearings after that initial date period. But Mr. Patterson was able to provide me some case law that appeared to show that that jurisdictional issue can't be waived by the defendant. That was kind of one thing I just wanted to make sure of. He did provide me some case law to that end. So I'm satisfied. I wish I could say that there is some sort of exception for hackers, but there's nothing I could find that I think would get us back right.
All right. Now, the court certainly understands Ms. Teal's statement regarding the disruption regarding filing and the deadlines that was created by the cyber attack on the court system's electronic filing system. It very well could have led to delays which prevented the filing of a timely request for revocation of probation in this case. It does appear from the dates provided that the ultimate filing in this case was outside the allowable 30-day window past expiration date for the probation, which means the court does lack jurisdiction to proceed with revocation at this point. Mr. Derringer. Darren?
Yes, I'm here.
Okay. Do you understand what's going on here?
Yes.
Okay, let me ask you, do you have other cases pending right now besides this one?
The only cases that I have for state is the 2 new charges that I had, which was Walmart theft and giving that 14-year-old a vape. And that's all I know of.
All right, I'm just curious as to you have any holds on you other than this?
Not that I know of.
Okay, obviously the jail will let you know.
Yeah.
All right, the court does find that it has a lack of jurisdiction at this time to proceed further on the warrant to show cause alleging probation violation. It does appear that the case is effectively terminated at this time. However, anything that has not been paid at this point will be referred, if it hasn't been already, to a civil collection agency for further handling. In other words, Mr. Derringer, if you owe money in this case, you still owe it. And you may be pursued in the future by a collection agency. However, you don't have any other responsibility to report or otherwise answer in this criminal case. So you're to be released on any hold that's connected with this current warrant to show cause. Anything related to case number 2022 CR 329 is dissolved, and you're free to go in relation to this case. Mr. Derringer, as I was alluding to earlier, if you have any other holds on you, I'm not releasing you from those. Just the case number of 22 CR 329.
Okay.
I hope that there is a representative at the jail handy who's hearing this matter currently before the court and can take appropriate action.
Yes, sir.
Okay. Mr. Patterson, is there anything else we need to address here?
No, Your Honor.
Obviously, no further waves will be connected with this round. Mr. Sweeney, is there anything further from the state's perspective that we need to address?
No, Your Honor.
Ms. Teal, anything further at this time?
No, sir.
No, thank you for your appearance here today. Last but not least, Mr. Derringer, you have any questions about what we've done here today?
No, sir.
Okay, you're going to be released on this case. Do you have somewhere to go?
Yes, I do. I have I honestly live in a tent at the Incomni Inn, and I have good friends there that are actually good friends that'll help me get a job and help me get a place.
All right, I hope so. All right, good luck to you, Mr. Derringer. I hope you're okay when you get out.
I will.
All
Thank
right.
you.
There's nothing further then. The Derringer matter will be in recess at this time. Mr. Patterson, are you covering Mr. Watts in his other case today?
I have not been contacted by anybody, Your Honor.
Okay. Thank you. Then I can go ahead and release you from the meeting, Mr. Patterson.
Very good. Have a good weekend. Thank you.
You too, sir. All right, Mr. Sweeney, let me ask you, are you aware of who is from the defense counsel side is handling Mr. Polson today? It does look like that Mr. Favre was actually appointed.
It looks like the email communication from Miss Norris to the defense counsel in this case looks like it's all been directed at Mr. Favre. So that was my understanding of who would be here today, but it's not my case.
The case I'm referring to, obviously, is State of Kansas versus Andrew James Polson, case number 2023 CR 481. There's an individual at the detention facility Zoom location. Are you Andrew Polson?
Yes, sir.
Okay. Have you talked to Joseph Favre about your case?
Yes, sir.
Okay, I'm not sure where Mr. Favre is.
Oh.
All right, I'm going to recess briefly. I'm going to have my assistant try to contact Mr. Favre, and we'll leave this Zoom meeting open until further proceedings are conducted. This time, the court resumes proceedings in State versus Polson, 23 CR 481. Mr. Sweeney, Joseph Favre is defense counsel, and Mr. Polson appears as before. This matter comes before the court at this time for further proceedings. This matter had been set for a plea hearing. Then the defendant failed to appear at the scheduled plea hearing on July the 15th. Eventually, apparently was picked up on a warrant and is in custody at this time on a no bond hold. Mr. Favre, what announcement is made regarding current status of the case?
Judge, this was set for a plea, and Mr. Polson had previously had consultation about that. He's ready to proceed with that plea at this time.
What's the plea he's attempting to enter here?
Judge, he'll be pleading guilty to an amended, I'm sorry, no contest, I apologize, to an amended count 1. And that amended count 1 will be amended to felony theft level 9, non-person felony. State has agreed to dismiss count 2. Pursuant to plea at the time of sentencing, Mr. Polson will agree to be sentenced at the high end number of the box, as well as agree to a reasonable restitution amount that will be provided by the state.
You're going to be able to reach an agreement on this restitution issue?
I believe so.
All right, I see an original charge in the alternative. I do not see a count 2. Were you referring to the alternative form of the charge? Mr. Favre,
Yes,
you're muted.
That's my understanding.
That's correct. It's an amended count 1 and not a count 2 dismissal. My mistake.
All right. I guess we'll handle what alternative is going to be the factual basis when the prosecutor provides those facts to the court during this plea. We'll go ahead and proceed. All right, Mr. Polson, you've been present when your attorneys made an announcement on your behalf as to how your case would be handled, which would involve you entering a plea of no contest and therefore accepting conviction for the charge of felony theft, a level 9 felony. Is that indeed your intention today, to enter that plea?
Yes, sir.
All right, I've got a number of questions I need to ask you regarding the taking of a plea of no contest. If there's any question asked of you that you do not fully understand, I'll give you the opportunity to confer again with your attorney privately along the way. Just let the court know if you need that additional time to confer, okay?
Yes, sir.
All right, state your full legal name for the record.
Andrew James Polson.
And how old are you right now?
36.
Okay. What's the highest level of education that you've attained?
Some college, associate's degree in applied technology.
Okay. Do you believe you're going to have difficulty understanding any of the legal concepts that we're going to be discussing here today?
I don't believe so.
Okay. I can't see from the record that you ever formally waived your right to a preliminary hearing. Do you understand that you would have been able to have a preliminary hearing where probable cause would be determined? Do you understand that?
No, not exactly.
Okay. At one time you were set for a preliminary hearing. The purpose of that is merely just to establish if there's probable cause to keep the case going.
Okay.
You understand that by entering this plea, you'd be waiving any such right?
Yes, sir.
All right. All right, Mr. Polson, have you ever been adjudged to be mentally ill?
No.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking mental health meds that you are not currently getting?
No, sir.
So as you participate today, do you believe your mind is clear and that you have a full understanding of what's going on in court?
Yes, sir.
Did you receive a copy of the original charges in the case?
Yes, sir.
All right. Do you understand the nature of level 9 felony theft?
Yes, sir.
All right. Essentially, it's stealing something that has a value of over $1,500. You understand that?
Yes, sir.
Okay. You understand that when you enter a plea of no contest, you are not necessarily admitting that you did that act, but you're also not contesting being convicted of felony theft just the same. You understand that?
Yes, sir.
You further understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to that charge.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Favre, and that you can present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case under oath at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, sir.
You understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
Yes, sir.
You also aware that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, sir.
You understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
You further understand that you may appeal your sentence after entering a plea of no contest, but generally you may not appeal your judgment of conviction after you enter such a plea.
Yes, sir.
Now, are you aware of the possible penalties that you face as a result of this no contest plea that you are attempting to make?
Yes, sir.
All right, let's go over those. This would be a level 9 felony on the non-drug offense grid under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I, you could receive as little as a 5-month prison sentence. However, in the worst criminal history category of A, you could receive up to a 17 months prison sentence. So the sentencing range is 5 to 17 months in prison, depending on your criminal history. Mr. Paulson, as you participate today, we do not know with certainty what your criminal history is. You better than anyone else here should really know what your own criminal record looks like. That will be researched by the Court Services Department. And based on the outcome of that research, as of the date of your sentencing, that will determine where you fall along the level 9 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
You also understand that if you have 2 or more person felonies on your record at time of sentencing, you will be presumptive prison in this case.
Sir.
Right. You also understand that you could receive up to a $100,000 fine for this offense.
Yes, sir.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed as part of your sentencing orders?
Sir.
You also understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, sir.
Wilson, you understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, sir.
You also understand that the Kansas Sentencing Guidelines Act contains what we call special rules. Do you understand that if there are any special rules that apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? Do you understand that?
Yes, sir.
Okay. Now, have you had an ample opportunity to discuss legal matters like that with your attorney, Mr. Favre, before proceeding here today?
Yes.
You want any more time with him privately now before we go further?
No. No, sir.
Are you satisfied with the services and advice given to you by Mr. Favre?
Yes, sir.
Now, this no contest plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
No, sir.
And you understand that if there have been any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that the court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. You understand that?
Sir.
So let me ask you formally, how do you plead to this charge of severity level 9 felony theft as charged in count 1 of the information?
No contest.
Court will be asking the prosecuting attorney for a concise statement of factual basis.
Thank you, Your Honor. I'll try and be as concise as possible. This is a extremely convoluted and long factual affidavit.
I just need to know what he did.
Okay. On Sunday of September 24, 2023, an individual contacted Butler County and basically reported that a Ditch Witch model SK800 mini skid steer and a black 2023 Shirt Track 6x12 flat bed trailer were taken from 203 North Oak Street in Whitewater, Butler County, Kansas. There were some ring images and then some additional security camera footage that showed the theft occurring. And that was acquired by law enforcement. And then several days pass, but the skid steer and the trailer, it looks like, had been rented from Andover Rental Center by Richard Snyder. And the law enforcement officers were in contact with Andover Rental Center. There was some Facebook messaging that had gone back and forth where individuals had basically reported to law enforcement and to this individual that a skid steer like it looks like it had been up on some websites basically for sale. That led them eventually to an address in 1832 South Wichita Street in Wichita, Sedgwick County, and they made contact with the residents at this address. There was a Erskine, a Branscombe, and a Polson. Officers felt that they could identify Branscombe and Polson as the individuals in the video. Erskine, one of the individuals said that Branscombe and Polskin were together that Saturday night and left the residence in the Ford F-150, which would have been consistent with the vehicle taking the trailer and the Ditch Witch that morning, that Sunday morning. She did not know where they picked up the property from, but informed the officer that Branscombe's mother lived in Whitewater. Additionally, there was on October 2nd, they got some additional information from another neighbor in that Wichita Street area that saw a individual, a young white male with a goatee wearing a gray shirt, riding a funny looking vehicle, followed by another individual on a bicycle that matches essentially the security camera video from Whitewater. So all of these things together, they kind of come together to show that Mr. Polson and Mr. Branscombe in truth were the individuals that took the skid steer and the trailer from the residents in Whitewater on or about the 24th. It looks like that's actually owned by Andover Rental Center and was being rented at the time by Mr. Snyder. Sorry, I try to be as concise as possible.
And the state's evidence would show they did not have any type of permission to be taking possession of these vehicles.
No, none, Your
Honor. The value of these items would be approximately how much?
Above $1,500. I think probably, in truth, well in excess of 25,000, but for purposes of the level 9 plea, definitely above $1,500.
All right. Mr. Polson, do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for the severity level 9 felony theft charge?
Yes, sir.
Mr. Favre, do you know of any legal reason why the court shouldn't accept your client's plea?
Not at this time, Your Honor.
Sweeney, are you aware of any such legal reason?
No, Your Honor.
Polson, are you aware of a legal reason or any other good reason why the court shouldn't accept your plea here today?
No, sir.
Court will accept the no contest plea made by the defendant and finds that plea is made voluntarily. He has an understanding of the nature of the charges against him and the consequences of the plea, and a factual base for the charge of theft does exist. Court finds him guilty and it judges him therefore convicted of severity level 9 felony theft. Court orders a pre-sentence report be completed to accurately determine Mr. Polson's criminal history. The court will set an appropriate date for sentencing. Andy, can you suggest a date on the February 2025 calendar, approximately 2 months from now?
We could use February 21st in the afternoon.
Barbara?
Judge, I'm presuming there's a warrant to show cause docket that afternoon. And I have a preliminary hearing, I'm sorry, a permanency hearing in a Greenwood County Sink case at 1:30. So if we want to do later, like 4, that would work. Or I have time later that morning, I think, as well.
We could use February 19th at 2 p.m.
Okay, I'm completely open that day.
Court will set sentencing in this case for February 19, 2025, 2:00 p.m. Mr. Sweeney, is there anything else that we need to address here?
No, Your Honor.
Mr. Favre, anything further?
Yes, Judge, we would like to address the issue of Mr. Polson's bond. It's my understanding, Judge, that Mr. Polson has a no bond hold at this time. I think he's being held only on this case as well. Mr. Polson, as the court noted, failed to appear at an earlier hearing set about the middle of this year, and he was gone for an extended amount of time. I inquired of him what was going on, and basically he told me that he made a mistake and failed to appear, and then he was newly hired at a job and didn't want to mess it up, so he kept going on with his life, which is obviously not a great response to missing court, shirking your responsibilities. But he has maintained staying out of trouble. He has not picked up new cases to my knowledge. He has very limited criminal history. I think this is his first felony ever. I don't think he has much by the way of misdemeanors. And he is employed at that job, which he has maintained for the last 6 months, which is doing landscaping and other work for a company called BG. I don't remember the exact name, but it's in Marion, Kansas, where he resides. So obviously missing court's very serious, but we asked the court to consider giving him another opportunity at a cash or surety bond of some amount, so that he can be out and support himself and his household between now and sentencing, and maintain the job which he hasn't lost as of yet, from what I understand.
Mr. Sweeney, what is the state's position regarding this request?
Your Honor, the state would ask that the court's previous orders remain. Looks like we didn't find him for quite some time after he failed to appear at the last hearing. So I think it's appropriate where it's at.
Mr. Polson, I'd like to work with you on this, and it would really be the preference of the court in a matter such as this, that you be out in the community while your case is pending, including even time after you've been convicted until the time of sentencing. That's the court's preference. But the court had established a bond for you before, and then when it was time for you to appear in July to enter the plea in this case, you didn't show up. And I think Mr. Sweeney makes a pertinent point here. This isn't one of those situations where you realize that you made a mistake and then immediately try to take care of it. Some people do that. They're very diligent about contacting the court, contacting their attorney, or just surrendering themselves to go ahead and face the music soon. You didn't do that. You stayed out in the community for apparently over 4 months. I see that you didn't even make an appearance after your arrest until December the 4th. You've been in jail about 23 days. I wish that I could consider you a good risk to let back out in the community, but quite frankly, I don't know what I would base that on. You apparently don't even live in the county. I don't really want to see you lose your job, but you maybe should have thought about that before you just kind of blew off court for 4 months. So Mr. Favre, I think, has made a good faith request on your behalf to have your bond reinstated, but I'm going to decline to modify the current no bond hold order. It's the one way that I can be assured that if they need to do a risk needs assessment on you prior to sentencing, they'll know where to find you. And I think that there's about a 99.99% chance that you'll be available to this court for the scheduled sentencing date if I leave you where you are. So regrettably, I'm going to have to deny the request of Mr. Favre and leave the no bond hold order in effect pending further proceedings in this felony case. We'll talk about whether you're an appropriate release candidate at time of your sentencing, Mr. Polson. All right. Mr. Sweeney, is there anything else we need to address from your perspective now?
No, Your Honor.
Favre, anything further?
No, Your Honor.
All right. Then the Polson matter will currently be in recess, and this meeting may be ended for all at this time.
Well, ladies and gentlemen, that's all she wrote. Tommy Lee has ruled, and the show is done. I don't really have much to say other than thank you very much for coming out. It's been an amazing chat. I had a great time. I really found these cases interesting personally, and I really enjoyed sharing these cases with you. I am your Lone Wolf Usul, and I am your host for these here live productions that happen every weekend at Saturday, 12 Eastern Time, 11 Central Time. Keep an eye out for more videos coming out all week long. Make sure you've hit the like and the subscribe buttons and do all the things. And ladies and gentlemen, keep on being you. We have the best community there is. I'll see you next time. Your Lone Wolf is out.